the petitioners originally filed a termination and adoption of the child back in 2018. And then there's been, I guess you'll hear everything that's gone on during that time. And then the child turned 18 about almost 2 years ago. And so we filed the petitioners then filed a amended SAPSR suit, which a SAPSR suit, a suit affecting parent-child relationship suit, had never been filed before, but they filed an amended pleading for a SAPSR just recently. And we filed a response to that and a motion to dismiss, and we'd like to present that to the court at this time.
All right. You may proceed on that then.
All right. Well, and Your Honor, like I said, this case was filed in 2018, I believe.
February 15th.
February 2018 as an adoption termination of the parent-child relationship to terminate my client, Mr. Charles Donovan Reid's parental rights. It was filed by the grandparents of the child, the maternal grandparents, Diane and Donald Ernest, I believe is how you pronounce it. The case stalled after discovery requests were filed against my client, responses made. Then the petitioners didn't do anything for about a year or so. There was, correspondence from our office. Finally, the attorney for the petitioners at that time, Mr. Black, asked to dismiss the case, which we responded by saying we weren't dismissing our attorney's fees and sanctions. And I believe the court's position when the child turned 18 was that the case was dismissed as a matter of law. We filed a brief with the court, which was eventually heard by this court in January, allowing us to move forward on our sanctions and attorney's fees. Subsequent to that, the petitioners just recently filed a first amended SAPSR suit claiming, offsets, I guess, to try and offset our claims for attorney's fees and sanctions by saying that they had possession of the child. Our position, Your Honor, is that filing is moot. It should have been. It was dismissed as a matter of law when the child turned 18, and I don't think the maternal grandparents would have standing at that point that they filed this SAPSR suit anyway. So we're asking the court to dismiss their first amended pleading for a SAPSR suit.
Mr. Kincaid, response?
Thank you, Judge. Judge, this case did start as a termination adoption case filed by the Ernest. They had possession of the child for a period of months prior to filing of that suit. They then had the child for a period of almost a year after they filed the suit. And therefore, by definition, this is a suit affecting the parent-child relationship. It just happens to be a termination of those parental rights and a request for an adoption. But it all is included in the same thing. It all has to do with parental rights, duties, responsibilities, including support. And so the fact that Mr. Foster says that should expire or terminate by operation of law, I don't know where he's coming up with that. I'm not sure where that would he would find the support for that. But the ongoing issue is that was still pending when I took over the case. And Mr. Foster says that it was the court's position. I reviewed entire file of the court's docket entries and orders entered. I don't see anywhere where the court said this was overruled by operation of law. I don't see anywhere where the court made any particular rulings or orders that Mr. and Mrs. Ernest's case was dismissed in any way. Don't find any of that. That was still pending, and they elected to modify their request to the court because obviously this child had turned 18. However, the issues of support continue, and as this court's aware, can be brought for up to 2 years by contempt. We're not asking for contempt, but could be brought for 2 years by contempt. And certainly this child didn't turn 18 until September of 2019. So we haven't even reached that 2-year mark yet for Mr. Foster to claim that there would be no jurisdiction or that they'd have no standing. I don't believe there was ever a standing lapse because that case had never been dismissed. In fact, it's still pending. As we sit here today, we're now amending that to be a first amended as a SAPSR and abandoning the modification or abandoning the termination and adoption portions of that. However, the support of it, the support portion of it is still what we'd like to proceed upon. I don't know. I don't know if Mr. Black asked for that to be dismissed or not. Again, I don't see that on the court's docket sheet. I don't see it in an order anywhere. As far as Mr. Foster's position that we're asking for offsets, no, we're asking for support for the periods that the child was living with the Ernest and they did not receive support for that child. That's what we're asking for. If that happens to be an offset, that's between Mr. Foster and myself based on what happens with the court, or it's up to the court as to how you would rule on the case. But we're asking for a judgment on support.
All right, Mr. Foster, response?
Yes, Your Honor. The original petition for adoption termination has no pleadings requesting any sort of support. That pleading, I believe, was terminated by operation of law. The child turned 18 years old almost 2 years ago. So that case is moot, except for the court. This court decided that our sanctions and attorney's fees go beyond that period of time and are not dismissed. The original petition, however, though, Judge, says ask for no pleadings requesting any sort of support for the child. The only time they've requested any sort of support was just recently when they filed their first amended SAPSR suit, which and the original petition for termination asks for nothing that the SAPSR suit is asking for. It doesn't ask for managing conservatorship or support or anything. It just asks to terminate the parental rights of my client and for the grandparents to be able to adopt. There was nothing in the pleadings about support from the father. And it's been almost 2 years since the child's turned 18. There's been no orders in the past ordering any kind of support. So I think that issue is moot.
Well, inherently, Judge, it would include support because one of the duties that Mr. Reid would have had would have been to support the child. And that was asking for termination of that duty and responsibility. So again, just because things aren't specifically laid out in that termination and adoption, it is a suit affecting the parent-child relationship in all aspects. It affects every aspect of the parent-child relationship by asking to terminate those rights. So I think all of those are by nature in play when it comes to whether or not this is affecting a SAPSR or part of a SAPSR. It's a termination and adoption of those parental rights. We call it a termination and adoption case, but for all intents and purposes, it is a SAPSR asking to terminate parental rights of one of the parents or both. And in this case, it asked to terminate Mr. Reid's rights, duties, and responsibilities, one of which included support. And so, again, Mr. Foster is saying or inferring that the court somehow dismissed Mr. and Mrs. Ernest's case, but left his case pending. Again, I don't see that anywhere, Judge. I don't see a docket entry. I don't see an order. I don't see anything to that effect. So I think that this case entirely was still pending. And Mr. and Ms. Ernest have the right to modify their request if they're no longer appropriate or they've changed over the period of time. And that's what they did.
All right. So just so the timeline is in my mind. The SAPSR, the first amended SAPSR was filed after the child emancipated. Is that correct?
Yeah, oh,
Yes,
yes, Your Honor. Just recently filed.
And there was no prior orders ordering Mr. Reid to pay support. So the first request for him to provide financial support was in this first amended suit affecting parent-child relationship, which was filed after the child emancipated. Is that
Yes, Your
right?
Honor.
The first affirmative request, yes.
All right. All right, the motion to dismiss the SAPSR request is denied. We're going to proceed with we're going to proceed with both aspects of the case. And Mr. Kincaid, you're the petitioner, so that means you get to proceed first. Anyone that's going to provide testimony, if you would, please raise your right hand to be sworn.
Mr. Miss Ernest, if you raise your hand. Right hand.
Ma'am, I can't see if you're raising your right hand. All right, thank you. Each of you solemnly swear or affirm the testimony you're going to give in this cause will be the truth, the whole truth, and nothing but the truth to help you God.
I do.
Mr. Reid,
Mr. Reid, you need to,
Mr. Reid, do you solemnly swear to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Thank you. All right, Mr. Kincaid, you may proceed with calling your first witness.
Miss Ernest, could you unmute, please? I'd call Diane Ernest.
You may proceed.
Just tap on that microphone. There you go.
Okay, got it.
Can you hear me?
Yes,
Please state your name for the court.
Diane Ernest.
And Miss Ernest, are you one of the petitioners in this case regarding your granddaughter, Jill?
Yes,
And ma'am, when you originally filed this case back in 2018, it was filed as a termination adoption case. You're aware of that, right?
yes,
And recently, you all have elected to amend your pleadings. Is that correct?
yes,
And at this point, you're only addressing the support issues with regards to your granddaughter, Jill, correct?
yes.
Now, let's talk about Jill for a few minutes. She's how old now?
She will be 20 years old at the end of September.
Okay, so she's 19, as we said
Yes.
today.
Yes,
And where is her mother?
she died in 2005.
Okay. And Ms. Ernest, we had gone through a timeline of events of significant things that happened throughout the course of since your daughter died till more recently, correct?
Yes,
Are you familiar with what has been marked as Petitioners Exhibit 1?
yes,
And does that accurately reflect the testimony you would give about a historical process through which the dates and times and the events are accurately reflected?
yes,
Judge, I'd offer Petitioners Exhibit 1 as a shorthand rendition of Ms. Ernest's testimony.
Any objection, Mr. Foster, to that being a shorthand rendition of her testimony?
I believe I received it. Is it, can we screenshot it? I don't know if I can find it right now.
I can, if you let me share screen, Judge, I can do that.
You have permission to share screen.
Ms. Ernest, is this what's been marked as Petitioners 1?
yes,
And does this accurately reflect the cycle of events from 2005 to 2019 of the things
Yeah.
that you want the court to be aware of?
yes,
All right. Judge, I'd offer it again.
All right, Minnie, do you have this exhibit? I see them. They were sent Thursday, August 26th. I've got it. Any objection to P1, Mr. Foster?
Yeah, Judge, I would just object as to relevance. I mean, they're going back many years before the filing of the termination case, which I believe is, and I'd like to get a ruling from the court that that case has been dismissed as a matter of law. There is no, should be no pleadings on termination adoption, and it looks like they're trying to get some kind of evidence, which I don't even know. I mean, testimony about something that existed before the termination adoption, but I would object as to relevance.
All right, the court's going to allow it, overrule the objection to P1, allow it as a shorthand rendition of petitioner's testimony. So P1's admitted.
All right, Ms. Ernest, if you see back in May of 2005, is that when your daughter passed away?
Correct.
And where was she living at the time that she passed away?
They lived in Beasley
And who was she living with?
with her husband and Jill.
Okay.
Well, I mean,
And-
she was in the hospital when she died, but her residence was in Beasley.
Okay. And did she receive any disability at or about the time when she was passing?
Yes,
And did your granddaughter receive any disability payments at or about the time that your
Judge,
daughter?
I would
passed?
object at this point
Yes.
as to relevance. I mean, we're going back and trying a, I don't know what kind of case. Their pleadings, which you've allowed them to move forward on, are asking for reimbursement for something that happened about 2 years ago, I guess.
What's the relevance, Mr. Kincaid, of whether or not daughter received benefits?
Judge, Mr. Foster has asked in his, as he's said all along, his claims to go forward. His claims are for attorney's fees and sanctions against the Ernest because this suit was harassing his client. And so I need to lay all of that out for the court so that the court gets an idea of how this suit came about and why it came about, and for the court to be able to make an accurate determination of whether or not this is harassing to Mr. Reid or not.
All right, I'll allow you a little leeway. Objection to relevance is overruled. You may continue.
Ms. Ernest, did your daughter receive also Social Security payments on behalf of her mother after she passed?
Jill, yes, she did.
And did she continuously receive those all the way up through when she turned 18, to your knowledge?
Yes,
All right. Now, in 2016, I'm sorry, April 16th of 2017, you said that Jill was hospitalized for psychiatric reasons. What happened?
she was suffering from severe depression, and her
Objection, Your Honor.
relationship.
I think that calls for speculation or hearsay. Unless she has
overruled.
personal knowledge of,
Overruled but please don't have
Well,
her refer to diagnoses. Hold on. Don't have her to refer to diagnoses, but she can tell about her observations of what Jill was going through at that time.
Okay, I saw the depression, and then I had paperwork from the hospital that diagnosed her as.
Objection,
Your Honor.
Okay,
Ms.
Hearsay.
Ernest, don't tell us what
Don't
anybody
say
said or what paperwork said, please, and don't talk about diagnosis, okay? We're just trying to get the basics here. So she was hospitalized in April of 2017, correct?
correct.
And how long did she stay in the hospital at that time, Miss Ernest?
She was released on May 11th of 2017.
Okay. Did you have any conversations or discussions with the child leading up to her discharge?
Yes, a week before she was discharged.
Okay. And ultimately, at the time she was discharged, where did she go to live?
She asked to come live with us.
That wasn't an answer to my question, Miss Ernest. Where did she go to live?
Her dad picked her up and she came to live with us.
Okay. So her dad checked her out of the hospital?
Yes, because we didn't have authority to do that.
All right. And did she spend any time living with her dad after she was released from the hospital in May of 2017?
No,
All right. Then she lived with you through September 11th, 2017, correct?
No, she lived with us from May of 2017 to December of January of 2019.
Okay. So in September of 2017, you, in your timeline, say that she was hospitalized again for 3 days. Is that correct?
Yes, on the first day of school because of her depression, and it was so overwhelming. She had a meltdown and went back in the hospital.
Okay. And had she been having any contact with dad from May through September?
From May through, no, she had no contact.
Okay. And when she needed to be checked into the hospital, were you able to do that at that time?
No, we had to contact dad to sign the paperwork.
Was dad available for you to contact?
Well, it was difficult getting in touch with him, but his brother reached him and he did come to the hospital.
Okay. Did he authorize for her to get hospitalized again during that time?
Yes.
All right. When she was released, where did she go from there to live?
She came back with us.
And continued to stay with you, I think you said, until January of 2019. Is that correct?
Correct. Yes.
Now, were there any indications from dad that he wanted Jill to come back and live with him at any time?
That he
During-
wanted, no,
During the period of May 11th through when you filed your termination in February 2018?
no, we had no contact with him.
So between that time, Mr. Reid didn't reach out or have any contact with you or with the child, to your knowledge?
After, in January of 2018, he had started to talk with her, but prior to that, no.
How was Jill doing with the contact with dad at that time?
She still suffered a lot with anxiety and depression, and she still was not sleeping well or doing good in school.
All right, let me ask you the next question, Ms. Ernest. Did Mr. Reid make any comments to you or your husband that prompted you to move forward with filing this termination and adoption at the end of 2017 or beginning of 2018?
He did talk to my husband when Jill was hospitalized
Okay.
in September.
Okay. And was it your understanding that he made it clear that he did not want this child to come back and live with him?
Well, that's what my husband said.
Objection, Your Honor, hearsay.
Sustained.
Well, ask
Hold on.
Donald.
Hold on, Diane. Okay. During the time that your granddaughter lived with you from May of 2017 until you filed the petition in 2018, did you receive any support from Mr. Reid for the child?
No,
Now, did Mr. Reid forward you any of those payments that he was receiving from Social Security on behalf of the child during that time?
no.
When was the first time that you received Social Security on behalf of your granddaughter, Jill?
In August of 2018.
At that point, she had been living with you for 20 months?
Well, May 17th to August, that would have been of the following year. Not yet. It would have been 12, 13, 14 months, 13 months.
Ms. Ernest, if you look at Petitioners Exhibit 2, you have that there?
Yes,
And if I went through each and every date with you on support payments received from Social Security or from Mr. Ernest, would that be an accurate reflection of the support that you received while your granddaughter was residing with you?
okay, now repeat that in Exhibit 2 or Exhibit 3?
I'm sorry, Exhibit 2. I'm sorry, Exhibit 3. you're better at the exhibits than I am, apparently. On Exhibit 3, would that be an accurate representation of the support that you received for your granddaughter during the months that she resided with you?
Yes,
Judge, I'd offer petitioners 3 as a shorthand rendition.
Any objections, Mr. Foster?
No objections, Your Honor.
P3 is admitted.
All right, Miss Ernest, during any of the months from May of 2017 through when you received the first Social Security payment, did you receive any support from Mr. Reid?
no,
After you got Social Security benefits coming in from the Social Security Administration for Jill, did Mr. Reid provide any support for you any of the months from August 2018 until January 2019?
no,
Did Mr. Reid ever forward you any of the money received from Social Security from May 2017 through July 2018 that he received on behalf of Jill?
no,
Did you and your husband support Jill during that time to the best of your ability for what she needed?
yes,
Did you receive any support financially from anyone during that time?
no,
Ms. Ernest, if you look at Petitioners Exhibit 2, would that be an accurate reflection of the monies that Mr. Reid received on behalf of your daughter or your granddaughter from Social Security that were not shared with you?
yes,
Judge, I'd offer Petitioners 2 as a shorthand rendition.
Any objection to P2 as a shorthand rendition, Mr. Foster?
No objections, Judge.
P2 is admitted.
All right, Ms. Ernest, during that time, Mr. Reid received over $22,000 from Social Security for the support of his daughter, correct?
yes,
And you're saying he didn't provide any support to you during that time?
no,
You think that that's right, that he kept that money for himself and not for the support of his daughter?
do I think it's right? No,
Did I have to give it back? Yes.
Mr. Reid, it's not your turn to testify yet, so if you can hold your tongue, and you'll get an opportunity to tell the court everything you want to tell the court, but now's not the time. All right, next question. Okay.
Thank you, Judge. Now, Ms. Ernest, if you look at Petitioners Exhibit 4, is this a letter that you received on behalf of your granddaughter regarding her benefits?
yes,
And is that a record that you kept on behalf of your granddaughter regarding expenses and items that are, I'm sorry, back that up, expenses and receipts that you had for her while she was in your care?
yes,
Judge, I'd offer Petitioners Exhibit 4.
Can I see that one, Judge? I don't seem to have that one.
We'll put it on the screen, Lonnie.
Yeah, if you could. Yeah, we have no objections to that.
All right, P4 is admitted.
Oh, wait, was that P4 that I was looking at?
Yeah, P4.
Oh, okay.
All right, Ms. Ernest, when did you receive this letter from Social Security?
in August, close to the time of the first check.
Right? And does that accurately reflect the amounts that you received on behalf of your granddaughter Jill after
Yes,
that date?
yes,
Now, Ms. Ernest, did you and your husband file this termination and adoption case to harass or intimidate Mr.
Objection, Your Honor, is deleting.
Overruled.
Did you or your husband file this case to threaten, harass, or intimidate Mr. Reid in any way with regards to your granddaughter?
definitely not.
Why did you file this case?
Because of the situation where she was at that time. We had her from May through all that time. There was no contact with Jill, her dad, and she wanted to go to take driving. There was different issues that came up.
Were you
for us
having
to-
any, were you having any issues with being able to make decisions for her regarding school or medical?
We did have authority for school, but her college, she was getting college letters. It was just a lot of different things and just her situation with her dad.
Well,
at
does any of that,
time.
Ms. Ernest, does any of that include decision-making about her medical?
Yes, because we had to go through him, and it was whenever she needed an appointment.
Was he cooperative in doing that and responsive?
Yes, as far as just medical office appointments, it was hard to reach him when she went into the hospital, but he did come to the hospital.
Ms. Ernest, on your timeline, you say that your granddaughter went back to live with her father in January of 2021. I'm sorry, 2019.
Correct, yes,
All right. And then she turned 18 in September of that year, correct?
yes,
When your granddaughter went back to live with her father at that point, did you have monies on account that you'd received from Social Security that were not spent on her at that time?
yes.
And what did you do with those funds?
I wrote 2 checks out to Donovan. I contacted Social Security to tell them she was no longer living with us, that she had went back to her dad, as I was instructed to do should she leave. And they told me to either send them the money that I didn't spend, or I could give it to Dad. I wrote out 2 checks immediately and gave that to Donovan for Jill.
All right. And you've marked exhibits 5, petitioners 5 and petitioners 6 as checks that reflect those funds. Is that correct?
Yes,
Are those true and accurate copies of the checks that you wrote to Mr. Donovan?
yes,
I'm sorry, Mr. Reid.
yes.
Judge, I'd offer exhibit 5 and exhibit 6.
Any objection?
No objection.
P5 and P6 are admitted.
All right, Ms. Ernest, on January 26th, you wrote a check to Mr. Reid for $1,645.11. Is that accurate?
Yes,
And it appears that Mr. Reid signed and deposited that check into this bank account, correct?
yes,
And then on January 25th of 2019, you wrote a check to Mr. Reid for $3,693.47. Is that correct?
yes,
It also appears that Mr. Reid deposited that check into a different bank account, correct?
yes.
Is that all of the funds that you had left that had not been spent on Jill at that point that you received from Social Security?
Yes, it is. And the bank account was closed.
Yeah, if you can stop sharing your screen if you're done with the exhibits. Mr. Gutierrez.
Yes, I'm trying to, something happened and all I have is a strip on the side. Oh, here we go. All right. Sorry about that, Judge. Couldn't find the right button. All right, Ms. Ernest, what do you want the court to do today with regards to your case and Mr. Reid's case?
What do I truly want to do with it? As far as just settle this, and
Do you really want Mr. Reid to write you a check?
no, I want Mr. Reid to pay his own legal fees as we've paid ours.
Pass the witness, Judge.
Mr. Foster, your witness.
Thank you. How much have you paid in attorney's fees to Mr. Black?
$3,500.
$3,500?
Yes,
How much have you paid to Mr. Kincaid?
$2,500.
All right. Now, you said that that you don't believe you were harassing or annoying Donovan Reid, correct?
Yes,
Statement.
yes,
So in February 15th of 2018, you and your husband filed a petition to terminate his parental rights, correct?
yes,
Not asking for anything else, not asking for any monetary compensation, correct?
yes,
All you were asking for was that his parental rights be terminated forever from his daughter Jill.
yes.
Okay.
At that
And-
time,
Well, that's what I asked you. Back then,
Yes.
you know what you filed.
right.
Okay. And at that time, had you ever asked Jill if she wanted her father's rights terminated?
Objection relevance, Judge.
What's the relevance, Mr. Foster?
Judge, I think that goes to harassment and annoying and what their position is on why they filed it. I mean, they obviously are talking about the child's mental state and what was happening with her. I need to know if these grandparents knew what was going on in this child's life and whether she wanted to be completely separated from her father legally. They obviously knew because they had her in their house.
That would be a situation, Judge, I think, where we need to keep the child out of that. And she's a child. She doesn't get to make decisions on that. But
Well, I understand that, but he didn't ask what the child said. He's just asking if they had a conversation with the child. So the objection's overruled. You may answer that, ma'am.
Yes, we did discuss this with Jill. It's my understanding she doesn't recall it, but it was discussed with her and her situation with her dad. And at that time, she was very bitter and upset and frustrated with the way things were with her dad. Very upset about no contact for Christmas and Thanksgiving, which Thanksgiving was a big deal in their family.
And she was a 16-year-old girl at the time, correct?
Yes.
And you're saying
Well, she turned 17. Yes, she was 16 when she came.
Okay. And when you filed it, she was what, 16, almost 17?
Yes.
Okay. And so you're saying a 16-year-old girl was having trouble with her dad?
They weren't speaking. They
Okay.
didn't speak till January.
You think that's out of the ordinary for a 16-year-old girl to be mad at her dad?
Well, at that situation from May till January was a little different than just your ordinary.
Objection, Your Honor,
Teenager.
non-responsive.
Overruled. I think she answered it.
Okay. So you discussed it with Jill and you believe Jill was ready to have nothing else legally to do with her father. That's your opinion.
Yes,
From what Jill discussed with you, you felt like her father needed to be completely out of her life legally.
I'm going to object as the relevance to that.
Judge, it's what they filed.
Overruled.
You're asking a child's opinion.
No, he's asking her opinion.
Yeah.
Okay.
So in your opinion, after speaking with the child and seeing the circumstances, you felt like you needed to just eliminate her biological father forever.
well, not exactly.
Well, that's what you filed.
Yes, I know it is what got
Okay.
filed.
All right. So that's what you filed. And then shortly thereafter, if you would have changed your mind about it, you could have just dismissed your case, correct?
Yes, and we did
And-
in May.
And yet you didn't.
No, we did in May of 2018.
You never
But-
filed a motion to dismiss this case, ma'am.
Mr. Black never filed the motion. We did not know that Mr. Black was supposed to file a motion.
Okay, my question is, did you ever file a motion to dismiss your case?
No,
Okay.
we
In
did.
fact, after that filing, you sent discovery requests to Mr. Donovan Reid, correct? requesting documents and answering questions?
Well, we didn't, Mr. Black did,
Okay.
but at that time is when
Right.
we told Mr.
Objection,
Black,
Your Honor, non-responsive after that.
Sustained after Mr. Black did.
Okay, so your attorney filed discovery, and you know what that was all about, because I'm sure you got copies of it, right?
no, we got paperwork to fill out, and at that time is when we told him we didn't want to
Objection,
go
Your Honor,
on with it.
non-responsive at that point.
Sustained after no, I guess. Next question.
All right, now. So the, you never, and then you, I think you testified saying that the reason you were doing this is because you needed to be able to control her schooling and health insurance and things like that, correct?
This characterizes the testimony, Judge.
Well, what did you testify to as your reason for filing this?
We wanted legal custody so that we could speak for her till she was 18.
Okay, did that also include terminating Mr. Reid's parental rights forever?
We never meant to terminate his rights forever.
Okay, but you understand that you filed that, even though your attorney physically filed it, you filed that against him.
Yes, now we understand.
Okay, yes, you agree with that. You and your husband filed a termination of parental rights against Mr. Reid in February of 2018, correct?
We wanted guardianship.
Okay, I'm not
He
asking you what
advised
objection, Your Honor,
custody.
non-responsive.
Sustained.
And we did.
Hold on, ma'am. Wait for the next question.
My question is, you and your husband, through your attorney that you hired, filed a termination of parental rights.
I'm going to
Yes,
object
we did.
this to ask and answer, Judge.
Sustained. Sustained.
Okay, but you'll agree with that, correct?
Yes, it was filed.
And you didn't ask for a term to dismiss your case, correct?
Objection, ask and answer, Judge.
Sustained.
All right. And on March 18th of this year, what did you file? Or do you know?
Yes,
What did you file?
the support for support.
Okay, and how old was your granddaughter for this when you filed for this support?
19. But
Okay,
it's for
she's
back.
19 years old, and you're now asking the court for support in March of this year.
Let me rephrase the question.
Okay,
Unless she, well, hold on. If there's an objection, there's an objection, but I understood the question. Ma'am, you may answer the question if you understood it.
We filed for support in hopes that Donovan would drop the $7,500 that he wanted.
okay, that's exactly true, ma'am. You filed it.
Objection to the sidebar, Judge.
Sustained.
Okay. Well, I'm asking her a question. You filed this because he was still seeking attorney's fees and reimbursement and sanctions. Is that correct?
Yes,
So that you could try and alleviate some of that possible ruling that may come against you, correct?
yes.
Okay. During the time that Jill was living with you and your husband, did you ever ask Donovan for any support other than the Social Security issue?
We didn't speak to Donovan when Jill was with us.
So is that a no?
Yes,
Okay.
it's no, we did not.
And as far as these checks that you provided to the court, you said that you wrote checks to Mr. Reid. Those were actually not funds from you and your husband, correct?
No, they were from the Social Security account.
Okay. Now, did you ever, while Jill was living with you, You made comments about her father to her, correct?
Objection relevance, Judge.
Judge,
Overruled.
while Jill was living with you, you made comments about her father to her, didn't you?
Like, what do you mean, comments to her?
I'm
Did
just
we
asking you if you
discuss the
made derogatory
situation?
comments about her father to her.
You say derogatory comments, Lonnie?
Any comments that you made about her father that may not be very nice. Let's put it that way.
Other than we were upset when she got upset when he said he was going to pick her up to take her out for dinner and then he didn't, or when he did things that we felt we saw her reaction to him protective. Yes, I can't say that, but as far as I don't feel that I said anything any more than each of you would say if you saw your grandchild suffering.
I'm asking you what you said to your granddaughter about her father while she was living with you. You don't recall?
Yeah, I recall it when she was living with us, what all went on.
Did you make the degrading comments about her father to her?
I probably did say that I felt it was unfair, and I sided with her when she talked with me about situations.
The main reason she came to live with you and your husband is that she was dating an older boy and her father didn't approve of it. That's correct? That's the main reason she moved in with y'all.
Well, that I'm really not even aware of that situation or the details of that situation. All I know is about the hospital stay, that she was in the hospital for over 30 days. When she was released, she had to continue her psychiatric counseling. Every day she went, we took her, and she finished school in a changes, a psychiatric affiliated situation. And she continued her counseling for the whole time she lived with us.
Objection, non-responsive, Judge.
Sustained.
So Jill would probably be the best person to let this court know why she moved in with you guys, correct?
Yes.
Okay. We pass witness, Judge.
Mr. Kincaid, anything further from this witness?
Just a couple, Judge. Miss Ernest, did you have issues with your attorney, Mr. Black, when this case started?
Well, we
How
did.
let me rephrase the question. Did you have issues with how Mr. Black handled the case based on what you hired him to do?
Yes, definitely.
All right. And was Mr. Black responsive to you throughout the case?
No.
Was Mr. Black responsive to the court or to Mr. Foster during the course of this case?
No.
Objection, that'd be speculation, Judge.
Sustained.
But did Mr. Black keep you and your husband informed of the things that were going on with the litigation, such as discovery or hearings and things of that nature?
No.
And you said earlier that you wanted Mr. Reid to just pay his own attorney's fees. Do you think it's fair that he would keep all that money and not support his daughter and then ask for
Objection,
you
Your
to pay
Honor,
a fee?
deleting.
Sustained.
You think it's fair that you should have to pay his legal fees?
No.
Do you think it's fair that he kept the money from Social Security and didn't provide it
Objection,
to
Your
you?
Honor, leading.
No.
Don't lead your witness. Objection sustained.
I didn't tell her whether it's a yes or no, Judge. I just asked her if she thought it was fair.
I understand the court, and the court's already heard that answer. So let's move on, please.
But for Mr. Reid pushing his issue with regards to the attorney's fees, would you have ever asked for this court to take any action regarding any support for Jill while she was with you?
Judge, Jack, I think that's already been asked and answered.
It has on to cross, but I'm going to let him, he's on redirect. So overruled. You may answer that, ma'am.
Okay, repeat your question.
But for Mr. Reid pushing the issue about you paying for attorney's fees and wanting you to be sanctioned, would you have asked this court to take any action on the support for Jill while she was residing with you?
No, we didn't initially want support.
Pass the witness, Judge.
Mr. Foster, anything further?
Just briefly, do you think it's fair that your granddaughter, that her father should have to pay his attorney's fees when you and your husband tried to terminate his rights? Okay, well, let me rephrase it. Did Mr. Reid initiate any of this?
Yes, he did tell my husband in September when she was hospitalized to take her that he couldn't do anything else with her.
Did he tell you or your husband to terminate his parental rights?
No,
If someone were to try and terminate your parental rights of one of your children, would you have been upset?
yes, I would be, but we're
No
not.
further questions, Judge.
Sustained. I mean, sorry. Thought you were objecting and non-responsive after yes, she would be. Mr. Kincaid, anything further?
Not from this witness, Your Honor.
All right, Mr. Kincaid, you may call your next witness.
Call Donald Ernest. Please state your name for the court, Mr. Ernest.
Donald Ernest. Say your name.
Oh, Donald Ernest.
Ms. Ernest, you can't say anything to Mr. Ernest during this process, so you need to remain silent, please. Please state your name for the court, Mr. Ernest.
Donald Ernest.
Mr. Ernest, you've listened to the testimony that your wife's given in this case, correct?
That's correct.
Do you believe that she's accurately represented to the court the way that things have gone over the past few years with regards to your daughter Jill in this lawsuit?
Exactly.
Do you think
That's
that
right.
she's misrepresented anything to this court?
No.
Now, have you also participated in helping to raise your granddaughter Jill over the last few years?
Yes, I have.
And back in 2017, previous to you filing your petition to terminate Mr. Reid's parental rights, did you and Mr. Reid have a conversation about Jill?
Yes, we did at the hospital that night. We picked her up. He said,
What did he tell you that you found significant with regards to this case being filed?
he told me to take her, that he couldn't do anything with her. And she had been in the hospital with the mental problem before we took her.
So you had already had her living with you for several months leading up to that conversation, correct?
That's correct.
And how did you take what he said to you as far as how that affected what you did or what you filed with the court? Maybe that was a bad question, but if you understand, go ahead and answer.
He didn't want to do anything with her anymore. Like I say, he was fed up with the situation. And he asked me if I'd take her. And I said, of course. And like I say, he's a grown man. He knew that he didn't send any money, in her behalf. It wasn't something that a man would have to ask another man to take care of his daughter.
Really?
Let me ask you the next question, Mr. Ernest. Did any time you consider filing anything to harass Mr. Reid?
No,
At any time, did you file anything with the intention of making him upset or mad?
no,
Do you feel like what you filed was appropriate given the circumstances of your granddaughter and the conversations you'd had with Mr. Reid at that point?
at that time, that's what I thought.
And at the time you filed that petition, Mr. Reid hadn't spoken with his granddaughter for over 6 months. Is that, I'm sorry, with his daughter for over 6 months. Is that correct?
That's correct.
Judge, I'll pass the witness.
Mr. Foster, your witness.
Thank you, Judge. So you're saying that to this court that you knew what you were filing, correct?
No, Mr. Black was the one that filed it.
Okay.
I know
Well, I thought
nothing
you
about the law.
told your attorney that you knew what you were filing. You didn't know what you were filing?
Not really. I'm not a lawyer.
Okay. What did you tell your lawyer you wanted to file?
What we wanted to file was this harassment that we were being charged with.
Well, I'm
I
not
wanted,
talking about, that was after you had filed, we filed a response, but I'm talking about initially, I think you told your attorney you knew what you were filing when you filed it. What were you filing?
for him not to be, wanting us to pay his legal fees.
Well, that wasn't at that point, Mr. Ernest. I'm talking about when you and your wife originally filed this case with Mr. Black. I think you told your attorney asked you if you knew what you were filing. I thought you said you did. Do you know what you filed initially in February of 2018?
We wanted guardianship.
Well, Judge, I object. I think she's writing him notes. He's looking
Yeah.
down.
I'm worried about that too. It looked like he just looked down. Mr. Ernest, Miss Ernest, you're not allowed to communicate with your husband at all when he's on the stand. He's got to testify from his own memory. If he doesn't know an answer, he can say, Judge, I don't know. It's okay to not know every single question, the answer to every single question that's asked, but it's inappropriate for a witness to help out another witness. So if that's happening, you need to stop it. I'm not saying it happened, but it looked like he looked down and so I want to make sure y'all aren't trying to communicate on notes. Mr. Ernest, you're not to look at any notes. You're to testify from your memory alone. All right, Mr. Foster, you may continue.
Thank you, Your Honor. So I'm asking you, I think when you were testifying for your attorney, I thought you said you knew what you were filing initially. Is that correct?
No, I don't.
So you don't know what y'all filed?
No, my wife takes care of most of that.
Okay. Did you know at any point after February of 2018 what you and your wife filed?
Guardianship is what we was after.
Well, okay. But do you realize that you and your wife, y'all are both listed as petitioners in this case, that you and her filed a termination of Mr. Reid's parental rights? Do you realize that?
I do now.
Okay, well, it went on for about almost 2 years before you and your wife decided to not go that route. Would you agree with that?
I paid Mr. Black to represent us.
I understand that, but I'm asking you.
He dropped the ball. He didn't tell us anything.
Okay.
We thought it was over with.
Objection, Your Honor, non-responsive.
Sustain.
I'm asking you, you and your wife are listed as petitioners. Y'all filed this. You should know what you're filing. It may have taken you a while to realize what you're filing, I guess, but you'll agree with me. It went for at least 2 years before you and your wife decided that's not what we want to go after, to terminate this parental rights of Mr. Reid. Is that correct?
We weren't advised by our attorney, Mr. Black, and what to do. He was out of the picture for 2 years. They said he passed away. Well, we just found that out here about 4 or 5 months ago.
All right. But will you agree with me that from the date that you and your wife filed this, it was about 2 years at least before you and your wife have filed anything else other than terminating his rights?
We didn't know that at the time. If we paid the man to represent us,
Yes.
and he was out.
Judge,
He
I
went
object,
somewhere.
non-responsive.
Sustained after, we didn't know that at that time.
Judge, can we ask the court to take judicial knowledge of the date of filing and from the date of the most amended pleading that they have?
Any objection, Mr. Kincaid, to me taking judicial notice of the dates of the pleadings by your clients?
No, Judge.
The court will take judicial notice of the date of the pleadings.
All right, thank you, Judge. Now, you said that you didn't file this to harass Donovan Reid, correct?
No.
How do
We
you,
filed it in Jill's behalf, where we could sign papers for stuff that she needed.
what, you said you didn't know what y'all filed, correct? Is that correct?
No,
Okay, so you know what y'all filed.
we filed guardianship. He wrote it up a different way. And
Okay,
when
well, you
we seen
understand that-
we said that's not what we wanted. And then after that, he was gone.
Okay. My question is, you were saying, you answered your attorney when he asked you if you filed this to harass Mr. Reid, correct? And you
Never had
said,
any
no.
intention. Never had any intentions to harass Donovan.
Okay, you said you
It was
didn't
all
file
about
it.
Jill.
You said you didn't file it to make him mad, correct?
No,
Okay. If someone were trying to terminate your parental rights of one of your children, make it to where you couldn't be the parent of them ever again, would that make you mad?
it all depends on the circumstance.
No, I'm asking you as a father. You're a father of children, correct?
Well, I treated my children right.
Objection, Your Honor, non-responsive.
Sustained.
I'm asking you if you had children, if you have children.
I have children.
Object
but-
is irrelevance, Judge.
Well, Judge, I think he asked him if,
Sustained.
so you don't think that Donovan Reid was mad or felt harassed when you and your wife tried to terminate his parental rights forever?
Objection calls for speculation, Judge.
Sustained.
Did you ever ask Donovan for any money while his daughter was staying with you?
No, but I was waiting
Okay.
for him to send us something.
Objection, Your Honor, non-responsive after that.
Sustained after no. Mr. Ernst, just answer the question that's asked. Don't volunteer more information.
Now you're saying that Donovan Reid told you, take her. I can't do anything with her. Correct? I think
That's
that was your
correct.
exact words.
That's what he told me.
Okay. Did you ever have a daughter?
Objection relevance, Judge.
I have 3 daughters.
Hold
One
on,
is dead.
hold on, Mr. Ernst. Objections overruled. Jim answer that, sir.
You had daughters?
Yes,
Okay. Does a 16-year-old girl, is she always going to listen to her dad?
mine did.
Oh, well, thank God. Okay. No further questions, Judge.
Mr. Kincaid.
I'm going to call my brother as a witness. He has 4 girls.
I'm gonna need a minute, Judge. Just a couple, Judge. Mr. Ernest, did you see Mr. Reid's behavior as being a responsible parent to Jill at the time when you all filed this petition?
Not at all.
And did you find that to be just a little off or completely off from what a normal parent, your position or your mindset would think a parent should be doing?
He was off.
And did you believe you were doing what you thought was in Jill's best interest at the time?
Yes, sir, I did.
Pass the witness, Judge.
Mr. Foster.
So you thought Jill's best interest was to take away her father forever?
He took his own self away from her.
No, I'm asking you. Do you think it was in Jill's best interest, in your mind, to
Yes.
take away her father forever?
All I wanted was guardianship. That's what we were at.
Objection, Your Honor, non-responsive.
Sustained.
My question is, do you think in your mind it was in Jill's best interest to take her father away from her forever?
No.
Thank you, Your Honor. I have no further questions.
Mr. Kincaid?
Nothing
Anything
further, Judge.
Mr. Kincaid, any other witnesses that you would like to call?
No, Your Honor, we rest.
Petitioner rest. This time, Mr. Foster, I'm assuming you think it's still going to be about 45 minutes to an hour. Is that right?
I was projecting that from my side. I didn't realize that it would, Mr.
I
Kincaid.
understand. So we're
But,
going to go ahead and break for lunch then. We'll resume at 1:30. Court's off the record.
I think.
Judge, do we need to log out, log back in, or?
I'm going to keep the Zoom meeting up. I'm just going to shut off the audio and video, so I won't be able to hear anything if y'all are talking. But that being said, you can log out and log back in. It'll be fine if that's what you prefer.
1:30?
1:30.
Thank you, Judge. It looks like Mr. Reed's in a different location. I'm just making sure he didn't move to wherever the other witness was.
No, he's still in my office, but I think he switched around the other side of the table.
Oh, okay, just turned around.
So the witness is not in the room. Just to
No,
confirm.
she's in our waiting room, and but she's gonna be the first witness we call in.
Okay, great. All right, Minnie, let me know when you're ready.
I'm ready.
Court's back on the record in cause number 18 DCV 248790, the Reid matter. When we left off for lunch, the petitioner had just rested their case in chief. We are now going to pick up with the respondent's case. Mr. Foster, you may call your first witness.
Yes, Your Honor, we're gonna call Jill Taylor Reid. Donovan, if you could just get your daughter to come in there.
We're going to need to swear her in. She hasn't been sworn.
I don't think so. Judge, I think I'm just gonna have her use the monitor that Mr. Reid was at, if that's okay.
That's fine, but the same, Mr. Reid, same instructions that I gave Mr. and Miss Ernest, and that is that no communicating, no writing notes, anything like that while she's testifying. And
And she's muted.
Miss Reid, did I don't recall swearing you in this morning. I know I did everybody else, but were you still present when I swore everybody in?
No, sir.
I didn't think so. Okay, if you would please raise your right hand to be sworn. Do you solemnly swear or affirm the testimony that you're going to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
All right, Mr. Foster, you may proceed.
Thank you, Your Honor. Can you state your name for the record, please?
Me?
Yes.
Oh, sorry. Jill Reid.
Okay, and you're Jill Taylor Reid, correct?
Yes, sir.
All right, and you know why we're here on this case?
Yes, sir.
What is your understanding of why we're in this trial?
A few years ago, my father had a disagreement with any parent child. And
I'm sorry. I'm sorry. She broke up a little bit. A few years ago, my father had a disagreement.
Me and my father had a disagreement, and we needed to work through our differences. And the best way to do that was a little bit of time apart, and it led to all of this.
Okay, and did you do you know what exactly was filed by your grandparents?
They filed for adoption, as far as I know. Yeah.
Okay, and
Yes.
termination of your father's rights?
Yes, sir.
Okay, when did you find out about that filing?
I was 16. I think I saw a piece of paper on the kitchen table at my grandparents' house, and that's kind of how I found out about it.
Did you approach them on it, or?
Not that I can remember. I don't ever remember being talked to about it. It was never discussed with me. I mean, obviously, I would have already said
Objection
no.
non-responsive after the initial answer, Judge.
Okay, so and what did you so prior to that, had you ever mentioned to your grandparents that you wished for your father's rights to be terminated?
No,
Relevance,
sir.
Judge.
Overruled.
Had you ever mentioned to your grandparents that you wanted your father's rights to be terminated?
No, sir.
At any point at that time when you were 16, and I think you said you and your father had some issues, did you ever wish to never see your father again, or?
No, sir. No,
Okay.
that was the case.
And did your grandparents tell you why they filed this?
I never was really ever given a straight answer onto why. It was all like,
Objection non-responsive after that answer, Judge.
Sustained.
What did they tell you about it?
I was really just told that they were filing for adoption and his like everything.
Objection
It was-
non-responsive after that answer, Judge.
Overruled. Is there anything else they told you other than that they were just for adoption?
Not necessarily really. I was told it was for so they could get adoption. There are differences I try to stay out of really, but then again, I was always brought into them.
Objection non-responsive, Judge.
Sustained.
Okay. Now, at about that time when you said you and your father had some issues and so you went to live with your grandparents, correct?
Yes, sir. Yes, sir. Correct.
Was that by agreement of all the parties?
In the beginning, yes, sir.
Okay. And at some point you decided to move back
Yes, sir.
with your dad?
Yes,
Okay.
sir.
And one, I guess for the record, let's make it clear. This is your father sitting next to you, Donovan Reid?
Yes, sir. Correct.
And your mother, who is your mother?
My mother is Cherie Reid. She passed away whenever I was young.
Okay, when you were about 4 years old or so?
I was 3.
3.
It was
Okay.
a few months before I turned 4.
Okay, and that's the grandparents who filed this case, that's her biological child. Or
Yes.
that's their biological child, correct? Your mother?
Yeah. Mhm.
Okay. Now, while you were living with your grandparents, were your grandparents, did they say good things about your father, Donovan?
Relevance, Judge.
But
What's the relevance, Mr.
Judge, I think it goes to whether their intent on filing this to harass and annoy someone. I think their opinion of the father goes a long way into what we're here for today.
But she testified that what she was told as far as what their intent was, already.
Well, I asked what they had told her about filing it, but I'm asking what they had told her about her father and what they thought of him. I think that's what they believe in her
All right, I'm
father.
gonna allow a little bit of it. Overruled. You may answer that, ma'am.
So did your grandparents speak highly of your father most of the time?
Absolutely not. No, sir.
What did they say specifically about your father?
There for a few things that stick out the most to me, anytime that I would have an idea of something I wanted to do with my dad, I was always told that it was stupid or why would I want to do that? There would be instances where even if I just said something about my dad and my stepmother, they would immediately just start bashing them. Whenever I was younger,
How would they bash them? What would they say?
growing up, not necessarily even growing up.
Judge, I'm going to object. I'm going to object to the time frame on this. I
Sustained.
think
While you were living with them during this time, what did they say about your father specifically?
That he was an alcoholic, that he was abusive, that he didn't ever really care about me, never, like, there was no structure or anything, that he just didn't care. Like, he didn't want to be a parent, and they made it they would say how he was never taking care of me and stuff like that.
What do you think about your father?
I can honestly say my father is one of my biggest supporters and has always been by my side throughout like everything. There wouldn't be, I could text my dad at any given time and my dad would be by my side in a literal heartbeat. Like there would be nothing that he wouldn't do for me.
Yeah. Okay. You understand? Do you understand that he paid our firm money?
Yes, sir. I understand.
Do you know how much he
Judge,
paid
calls
us?
for hearsay.
Sustained.
Okay. But since being back with your dad and talking about things, how do you think this termination against him, how do you think what has that done to your father?
I have
Objection calls for speculation, Judge.
Sustained.
From what
She
you've
can talk
seen.
hold on. She can talk about observations she's
Yeah.
seen from her dad, but not what he's not what he's thinking.
Well, what your dad has told you about this case to you, and things that you've observed, what do you think that's done to him?
I'm going to object to the things he's told her about the case, Judge. I don't know what they are, but certainly they could be self-serving hearsay.
Well, Judge, that's not hearsay. He's a party.
It's not an admission by a party opponent. It's not, this lady's aligned with him. So the objection hearsay sustained.
Well, Judge, I don't think she's aligned with him. The petitioners are the ones who are saying they want to be parents. So I think she's kind of in the middle. They're the grandparents. I mean, and he's the father, but why does that align her with my client?
She can testify about what observations she's seen from her dad as it relates to this lawsuit and how it's impacted him. But we're not going to get into what he's told her because I believe it's hearsay.
All right. So from what you've observed, how do you think that's affected your dad and what you've seen?
It's taken a great emotional and physical toll on him. I've never seen my dad cry until this case has came. It's like I've seen the devastation in his face and in his eyes, and I can tell that he's like truly tired and upset, and like he's at a loss because he's at one point he doesn't want to lose me, but at the same time he's battling with the woman that he loved dearly. He's battling with her parents. So like, I can understand that it's like hard for him because they were a big factor in his life whenever he was younger and whenever I was younger, and seeing that like relationship deteriorate. My grandfather and my father used to be the best of friends, and now there's absolutely nothing there. I can tell that it's taken a toll on him emotionally and physically. And I feel like it has put him in the wrong headspace. Like if you have
Non-responsive, Judge.
Sustained.
Okay. And so Jill, in your opinion, from what you've seen, being at your grandparents and things they've told you and being around your father, in your opinion, do you think that they did this to harass and annoy your father?
Objection calls for speculation, Judge.
Overall, I'm going to allow her to give her opinion.
What's your opinion about it?
I feel like partially it has been to harass and like attack my father. I also feel like
Objection non-responsive.
Overruled.
And what?
I also feel like they are trying to get my mother back through me.
Objection,
like-
Judge. This is not an answer to his question.
Sustained.
We'll pass the witness, Judge.
Mr. Kincaid.
Ms. Reid, you've had lots of issues throughout your childhood with regards to your dealing with the things that have gone on in your life with your mom passing and other things that's led to a lot of mental health issues for you, specifically when you were under the age of 18. Do you agree with me on that?
I don't necessarily feel that my mental illnesses and stuff is because of this and caused of this. Genuinely growing up, you have issues. Everybody has depression. Everybody has anxiety at some point in their life. I don't purposely on just because of the situation.
Okay. Well, you've had those issues in your life for whatever reasons, growing up as a kid and before you turned 18, correct?
Yes, sir.
And at one point in the early 2017, you were hospitalized for a period of a month. You recall that?
Yes, sir.
You'd been hospitalized prior to that, before April of 2017, correct?
I went to a hospital, got out, or I went to one for a week, got out, and the same day that I got out, I went to a different one. So I guess, yeah.
Okay, so my point is that that wasn't the only time leading up to that you'd been involved with mental health professionals and in emergency type situations prior to April of 2017, correct?
Incorrect. That was the first time, not the time that I was there for a month, but literally like the week before, whenever the whole situation started between me and my father, I was in a mental hospital. Yes.
The answer would be yes, correct?
Sure.
And then after that month-long stay later in 2017, you spent a few days being hospitalized to deal with some of the issues you had going on. Would you agree with me on that?
I have really bad anxiety and it was my first day at a new school, so understandably, yes.
The answer is a yes, correct?
Correct.
All right. Now, from the time when you left the hospital in May of 2017, you reached out to your parent or your grandparents and asked if you could come stay there, correct?
Yes.
All right. And they agreed and you left the hospital. Your dad checked you out and you went with your grandparents. Would that be
Correct.
accurate? And during the time from when you went to live with your grandparents until January of 2018, did you have any contact with your dad?
Yes.
What type of contact did you have?
He would show up to my dance competitions and to football games whenever I was performing. I would go out to eat with them occasionally. I would text my parents almost weekly. There was also, I went to therapy and my dad was there for every therapy session.
Do you think that that was between April of 2017 and January of 2018?
Correct. Yes, sir, it was.
So why were you so upset when your dad did not reach out to you for Thanksgiving 2017?
Don't you like to see your family on holidays?
Hold on, ma'am. You're not to ask questions. You're to answer questions. Just answer his question.
That upset you, didn't it?
Yeah.
It upset you when your dad didn't reach out to you regarding Christmas 2017, correct?
They invited me to Christmas.
I'm talking about you. So you're talking about at your dad's family, right?
Yes.
But your dad didn't show up to Christmas. You went to your Christmas celebration with your dad's family, but your dad wasn't there, was it?
I rode with my dad there.
So you think that there was no reason why your grandparents would have needed to get authority to make medical decisions for you?
My father had given them consent and had it written down in paper and everything, saying that if there was any medical needs or issues or anything, that they had authorization to take me to a hospital or take me to wherever I needed for medical needs.
Do you agree with me, Ms. Reid, that there were probably things that occurred between your dad and your grandparents that you weren't aware of at that time?
Yes, sir.
Now, how long was it that you did not have contact with your father when you went to live with your grandparents?
Maybe the first 2 months of living there while things were still extremely tense. And it was kind of hard for us to talk to each other.
You said your dad was at a loss with regards to these pleadings that were filed. When was that? When did you see that?
I don't quite remember.
Was it when they were first filed, or was it sometime later?
I'm guessing a few weeks after they were filed, whenever I saw the papers. I'm not quite sure how long they took to be mailed or anything like that, so I'm not sure.
When you saw the papers, did you see your dad?
No.
So it wouldn't have been at that time. It'd have been sometime later, correct?
Can you say your question again, please?
Wouldn't have been at the time when it was filed or when he was served, because you didn't see him at that time, correct? So it would have been sometime after the fact.
Correct.
But you don't remember specifically when that was.
No, sir.
I'll pass the witness, Judge.
Mr. Foster, any redirect?
No further questions of this witness, Judge.
May this witness be excused from the rule?
Yes. Yeah.
Yes, Judge.
All right, ma'am, you're more than welcome to stay in the room if you'd like to stay in the room, but Mr. Reid will need to be back on the screen. You're finished testifying. Thank you very much. All right, Mr. Foster, you may call your next witness.
Yes, Your Honor, I'd call Charles Donovan Reid.
You may proceed.
Thank you. Can you state your name for the record, please?
Charles Donovan Reid.
And you go by Donovan Reid?
Yes, sir.
Okay. Can I call you Donovan?
Yes, sir.
All right. So Donovan, you were served with papers back in probably March of 2018. Is that correct?
Yes, sir.
And what was that that you were served with?
Termination of my rights of my daughter.
Okay. And did you come to our office to seek counsel?
Yes, sir.
And you hired our firm to represent you?
Yes, sir. I was not going to lose the custody of my daughter.
Okay. And at that time, I think you had paid us to date $7,500, correct?
Yes, sir. That
Towards
is
the
correct.
case. And we've also we've filed a list of itemized time, and it's well over $10,000 at this time. You understand that, correct?
Yes, sir.
For our time. And do you believe our fees were reasonable and necessary for this particular case?
Yes, sir.
All right. Now, when you were served with these papers and you realized what it was about, how did you feel about that?
It was, I'm going to say aggravating to say the least.
So
It wasn't nothing that was called for.
So you were served by your ex-wife's parents, correct?
Yes, sir.
And that would be Diane and Donald Ernest.
Yes, sir.
Did you ever have any major problems with Mr. and Miss Ernest over the years?
Before now, no, sir.
But how did that make you feel when they're trying to terminate your parental rights and adopt your daughter?
It was rough. It was, I looked up to Donald as my dad. Him and I, we spent many hours together, rather hunting, fishing, whatever it was. We spent many, many hours together. And when this suit came about, I was devastated.
So,
And-
yeah.
And I have no other, I don't know what else to do.
Yeah. Okay. And so anyway, this has gone on for over 3 years. Is that correct?
Yes, sir.
And have you tried to resolve it with the other side amicably?
No, there has been no communication.
But there's been talks about trying to work this out without the court, correct?
That is correct. Yes, sir.
But no budging or agreeing from Mr. and Mrs. Ernest, correct?
Objection,
No,
Judge.
sir.
It calls for settlement
No.
negotiations, which would be confidential.
Sustained.
Then what, and in the more than 3 years, it would have been possible for the petitioners, the Ernests, to dismiss their case, correct?
Objection
Yes.
leading, objection relevance, Judge.
Sustain the leading. Don't lead your witness.
Do you believe that Mr. and Miss Ernst could have gotten rid of this case in some way?
Yes, sir.
Speculation, Judge.
Sustain.
It's just on speculation. Do you know anything about this case, Mr. Reid?
Only that they tried to take my daughter away from me.
Okay, and do you know anything about the legal system of filing cases or dismissing them?
I know a little bit. I followed it on Tyler Paul, and I know the things that have been filed.
Objection
And
non-responsive, Judge.
Sustain.
Okay, have the Ernsts in the 3 years that this thing has been going on ever tried to tell you personally that they would want to get rid of this thing?
No, sir.
Objection, Judge, calls for speculation on settlement negotiations.
Overruled. He's asking if they told him. Overruled.
Okay, now, what, in your opinion, Donovan, do you think why do you think they did this to you?
Objection, speculation, Judge.
Sustained.
Okay. Do you feel like they were harassing and annoying you, in your opinion?
Yes, sir, I do.
Meeting, Judge.
Overruled. Go ahead.
Why do you think they were harassing and annoying you?
Objection calls for speculation, Judge.
Overruled. He can give his opinion as to why.
Because it's always been a battle with them. Always. Especially after my wife died.
And since the filing of this 3 years ago, or over 3 years ago, is that another factor that?
Yes, yes, sir.
You and your daughter have a good relationship?
Yes, sir. Damn right we do.
And have you ever considered not being her father?
No, sir.
What are you asking this court to do as far as today, and why we're here?
As of today, the only thing that I'm asking for is for my attorney fees.
Are you asking for anything additional? You've pled for attorney's fees and sanctions?
Objection,
Attorney
leading,
fees.
Judge. He's already answered the question.
Well,
Hey,
Hold on.
I'm
Hold
just
on.
covering what the pleading state.
I know it's sustained as a leading. Please rephrase your question.
All right. Is
yes,
that the
sir.
only thing you're seeking?
Attorney fees and sanctions, yes, sir. I have missed countless days of work.
Objection, non-responsive,
Because
Judge.
All right.
Sustained.
Why are you asking for sanctions in this case? That's been going on for 3 years.
Because I have missed countless days of work for this. I have gone to many, many doctor's appointments because of this. And just the simple fact of harassment. This is crazy. She's damn near
Objection,
20 years
non-responsive,
old.
Judge.
Sustained.
you're-
At this point. Next question.
All right. Is there anything else you'd like to tell this judge about this case before we finalize this?
Yes, sir, I would.
Objection to the form of the question, Judge.
Overruled. You can continue, sir.
Thank you. Last night, my daughter drove in from San Marcos. My daughter slept in the same bed with me. This is crap. And what they are trying to do is BS. I don't know what else to say, but what they're trying to do is BS. And they have tried for the last 20 years to get me on something. Your Honor, I'm finished.
Thank you.
That's all we have, Judge.
Mr. Kincaid,
what-
your witness.
Judge. Mr. Reid, you understand that once your daughter turned 18, there wasn't any threat of terminating your parental rights and taking your daughter away, right?
Yes, sir. Do you understand?
Objection, non-responsive after yes, sir.
Sustained after yes, sir.
And Mr. Reid, if this was about ever since your wife died, this being some kind of vendetta by the Ernest against you, why did they wait 13 years to take any action, sir?
Beats the hell out of me.
Well, you don't think it has anything to do with the fact that your daughter had lived with them for 9 or 10 months at that point?
Why don't you ask her?
I'm asking you, sir.
Ask her.
All right, sir,
Asking
just-
you, sir, do you believe
Hold
that
on,
there's,
hold on, hold on.
Objection.
Mr. Reid, you have to answer the question. You're not allowed to direct him who he needs to ask. If you don't know the answer, you can say, I don't know, but you need to answer questions.
Yes, sir.
Continue, Mr. Kincaid.
Sir, my question was, do you believe that they're taking any action had anything to do with the fact that your daughter had been living under their roof for 10 months exclusively at that point?
Objection, Your Honor, speculation.
Sustain.
Judge, that's already been in evidence with regards to the timelines and the documents that we put in the testimony of the Ernest prior.
Yeah,
So I don't
I
think
heard,
that's-
I heard that they were there. You're asking them what's going on in their brain as to why they filed that action. So the conjecture.
Okay, sorry, I asked a bad question. I apologize. Didn't even remember or understand my own question. All right, so Mr. Ernest, do you think
Mr.
that-
Ernest isn't here.
Okay, Mr. Reid, do you
Yeah,
believe that you not having paid support during the months that your daughter was living with the Ernest had anything to do with them filing?
When it came down to support and Diane
Sir,
went
that's-
to the,
Objection, non-responsive, Judge.
Judge, I think he's trying to answer it.
I think,
It's a
trying to
yes or no
fucking
question.
answer.
hold on. The objection sustained. Sir, do you think that had anything to do with it? Yes or no? Your lawyer is going to get to ask you additional questions if he thinks you need to explain an answer. So Mr. Kincaid's allowed to ask you leading questions that may call for a yes or no response. So listen carefully to his questions and just answer the question that's asked, knowing that Mr. Foster will have an opportunity to let you explain your answers. Do you
Yes,
think
sir.
the fact that there was a period of time where there was no money paid towards the Ernests, that might have contributed to their decision?
Well, and Judge, I would object to that as relevant. They have no pleadings except for one they filed 3 months ago. And I don't think there's anything that's relevant to this case today. It's set for trial on my sanctions and attorney's fees. They have no pleadings requesting reimbursement of fees. So I object.
That's
to
not
that.
true, Judge. It's set for trial on everything.
It's,
And one of the basis for a termination and adoption is failure to support. And the
Right.
reason that was filed, that is the question I'm asking him.
well, and Judge, you look at their
Hold on.
pleadings, there is nothing in their pleadings about that.
I know, but you're asking for sanctions for the frivolous filing of a termination. And he's allowed to ask questions as to what the status was at the time that termination was filed. So the objection's overruled. I find that it's relevant as to what Mr. Reid thinks, so he may answer that question. If you remember it.
no, what is your question?
Question is, Mr. Reid, do you believe that the non-payment of any support for your daughter during the 10 months leading up to their filing might have had anything to do with the reason they filed?
No,
Okay. Did you pay any support for your daughter to the Ernest during the May 2017 till February 2018?
no,
Did you send any of the Social Security payments that you received on behalf of Jill to the Ernest during those months that she was residing with them?
no,
And you think that that didn't have anything to do with the fact that they filed for the termination case for your daughter?
they should have asked me, but no,
Do you deny telling Mr. Ernest that you couldn't do anything with Jill to just take her?
no,
Okay, so what drawing? Mr. Ernest, you said you'd missed countless.
Hold on. I'm sorry for the interruption, Mr. Kincaid, but I need clarification. His question, Mr. Reid, was, do you deny saying that? And you said no, which tells me that you did say it. I want to make sure I understood that correctly. Did you tell him that or not?
no, I did not.
Okay.
All right, Mr. Reid, you said you missed countless days of work dealing with this case, correct?
That is correct.
You think that's a basis for why they should have to pay your attorney's fees?
Why not?
I'm asking you the question. Is that a yes
Yeah.
or a no?
That
Okay.
is a yes.
All right. And so do you think that them dealing with your daughter's health issues or day-to-day schooling and all of that during those 10 months, and then another 10 months after that, should be a basis for them getting any kind of compensation from you?
Tell me what day that I did not provide insurance.
I didn't ask about insurance, sir. I said support. We just went through.
I don't give a
And you
damn.
told-
You asked me about insurance.
I
She
didn't
has
ask about
had insurance from the day she was born.
Mr. Reid, let me finish my question and then we'll go from there. We just went through, you didn't provide any of the Social Security money to the Ernest, nor did you provide any support out of your pocket during that time to the Ernest, correct?
That is correct.
Okay, so my question is the basis for you wanting them to pay your attorney's fees is you missed a bunch of days of work? Wouldn't the equivalent be that the Ernest spent a whole bunch of days taking care of your daughter that they were never compensated for by you? Do
No,
you think that's a fair response?
no.
Okay. And what exactly is it that was harassing to you by the filing of this petition?
Exactly. The filing of this petition.
Think that was harassing, so there hasn't been any justifiable reasons that the Ernest would have filed that?
Did they ask for anything?
Sure, again, we're asking the questions. You just need to provide answers.
No,
Do you think supporting your daughter is a bunch of BS?
no,
Then why didn't you?
I did.
What support did you provide while she was living with the Ernest?
Contrary to most belief, I talk to my daughter on almost a daily basis.
Okay, well, I'm asking about financial support, Mr. Reid. What financial support did you provide the Ernest while your daughter was living under their roof?
None.
And you
Did they
think that
ask for
that's-
any? Did they ask for any?
Judge, can we please ask the witness?
All right, Mr. Reid, quit
Yes.
asking questions. Your lawyer is going to make the arguments. You've got a very good lawyer that knows the arguments that he needs to make to try to convince the court to do certain things. I
Yes,
need
sir.
you to just focus on being a witness, and that means just answering questions, not asking questions. Mr.
Yes, sir.
Kincaid, next question.
So, Mr. Reid, you think it's BS in your terms that the Ernest would be asking this court to order that some support be paid for your daughter while she was with them?
No,
Then why would you think that they should be paying your attorney's fees?
because I said so.
All right, pass the witness, Judge.
Mr. Foster.
Donovan, did you initiate these proceedings?
No, sir, I did not.
Did you do anything to make it go over 3 years?
No, sir.
Have you done everything you can to try and end it?
Yes, sir.
Were you providing health insurance for your daughter throughout this whole time?
Yes, sir.
And how much was that insurance a month approximately?
I'm gonna say $100 a month. I don't know without
Okay.
my paperwork from work.
That's fine. And as far as the Ernests, did they ever ask you for financial support while your daughter was living with them?
No, sir.
Pass the witness, Judge.
Kincaid,
Nothing further, Your Honor.
Mr. Foster, you may call your next witness.
Just calling myself for attorney's fees, Judge.
You may testify in the narrative, and if you hear an objection, please let me rule on that objection before you continue. You may
All right,
proceed.
thank you. And Your Honor, we have respondents exhibit number 1, which is just a itemized list of our
No objection, Judge.
R1 is admitted.
My name is Lonnie Foster. I've been practicing in Fort Bend County and Texas for over 20 years, and I've been practicing family law in Fort Bend County and surrounding counties for that entire time. I'm familiar with this type of case. Mr. Charles Donovan Reid hired our firm back in 2018, and we've incurred time and costs, which as of August 13th, 2020, totaled up to approximately $9,300. There have been approximately 10 hours since that time. We just haven't updated for today. And also, I believe my client testified that these are reasonable and necessary fees, and we're asking for reimbursement of that time and costs to date. Pass myself.
Mr. Kincaid,
Foster, did you have an employment agreement with Mr. Reid?
Yes, I did.
And you haven't provided that as an exhibit?
I provided it in discovery back in 2018.
Does that employment agreement call for a flat fee or an hourly fee?
It calls for hourly,
And what is the rate per hour?
$400 an hour.
And what was the agreement with Mr. Reid as far as how that would be paid?
It was initially paid up front with the hours to be calculated at the end.
So Mr. Reid paid you $7,500 up front, correct?
Initially,
And you didn't provide him any regular billing or anything until 2000, August of 2020?
no, this was for trial when we were set in for trial back then in August or September, I believe. He's been
Have any
provided,
item? Go ahead, I'm sorry.
he's been provided updated statements since that time or before that time.
So what is this exhibit 1? Is this a summary of that? Is this a recitation of that specifically? What is this?
This is an itemized list of time on this case from February 28, 2018, when I was hired, through August 13th, 2020.
This is accurate based on the time you spent on the case.
Yes, this is accurate up to that point. That was when we were set for trial last, and then we've been obviously reset several times.
Mr. Foster, you created this list in August of 2020, correct?
Well, the time, yeah, we created this exhibit from the time in the file.
Okay, but you said you provided a timely or a breakdown of the time to Mr. Reid on a regular basis up to that point, correct?
We've provided him with updated invoices throughout this case.
This is the only invoice that you've submitted for court today.
Well, actually, I submitted it back in August of 2020, so it's just the same exhibit we were prepared to go to trial on back then. I just haven't filed an updated version of it.
Mr. Foster, if you look at September 29th, 2019,
Yeah,
see that line entry there? You prepped for the hearing and reviewed the file. An hour and a quarter for that. You see that?
yes, that was on a motions hearing that was heard by Judge Mullinex, I believe.
That motion that you prepared for and reviewed the file an hour and a quarter for was a motion to waive mediation.
Well, that wasn't the only preparation we made for. The motion for mediation was heard that following day, but I was reviewing the file for all other issues.
Then on November 7th, 2019, you said you drafted some motions. What motions were you drafting, sir?
Those, I believe, were the motions that were eventually heard by this presiding judge. And we drafted a motion and I believe a brief concerning our sanctions and attorney's fees.
Well, it says you
Research.
drafted motions, so I'm trying to figure out which motions you drafted. Do you know which motions you drafted?
I'd have to look that up, but I know that time period was when we were trying to get a hearing in front of Judge Mullinex concerning, which Judge Mullinex had informed me that she believed the case was,
Objection, Judge, calls for hearsay.
Sustained.
Mr. Foster, if you look again on December 17th, you have another entry for drafting motions and filing them. What motions did you draft and file on that day?
I'd have to look through my file that,
If I told you there were no motions on the court's website that were filed by you after that date, is that an incorrect entry or you just decided not to file the motions that you drafted?
I'd have to look through my file. I don't have recall of that date in 2019, but
And then on August 11th of 2020,
well, that was, okay, go ahead.
On August 11th of 2020, you're billing 3/4 of an hour to put together this spreadsheet or bill or exhibit, whatever you want to call it, correct?
Yeah.
And this is just a summary of the previous bills that you said that you'd sent to Mr. Reid.
Well, previous statements and then also a review of time that hadn't been accounted for. And that's the accurate amount of time that it took to go through the file and come up with a exhibit to file with the court.
That's the witness, Judge.
Mr. Foster, any redirect?
No, Your Honor.
Any other witnesses you'd like to call, Mr. Foster?
That's all we have, Judge.
All right, Respondent rest. Any rebuttal, Mr. Kincaid?
No, Judge.
All right, I'm going to give each side a brief closing. Each of you have 5 minutes or so. Mr. Kincaid, since you represent petitioner, you may proceed.
Thank you, Judge. Judge, this case should have been and always has been about this girl, Jill Reid. It's obviously a difference of opinion as to what was in her best interest at the time. But that's not really the focus. The focus in this case has been about money by Mr. Reid. Everything's been about money. But if you look at Mr. Reid, was it right that he didn't send any money to support his daughter? No. And he adamantly says he doesn't think he should, essentially. That wasn't something that would have been something he would have done, doesn't think it was required. Was it right that he kept all the funds from the Social Security and didn't provide any of those for the support of his daughter? No, because it was about the money for Mr. Reid. He collected those funds, used them for his own benefit, while his daughter spent 20 months with her grandparents with no support from Mr. Reid. He was getting the money from Social Security. He never paid any of it to the Ernest. He got the money from the Ernest whenever their period of possession or the child no longer lived with them, went back with dad. They immediately turned over $5,000 to Mr. Ernest. So he got that money. And now he's here today saying, give me another check. I shouldn't have had to gone through all this. Well, I think the key thing for the court in this whole situation is that it doesn't matter if Mr. Reid felt offended or upset or anything else. For you to sanction Mr. and Ms. Ernest, you have to find that they filed this for the purpose of harassment. It's an intentional thing. It isn't just what was the result. Oh, okay, he was upset. That's not the measuring stick, Judge. The measuring stick is, did they file this for the purposes of harassing Mr. Reid? Well, obviously the answer to that is no. We pointed out through the testimony and the evidence multiple things that led up to the filing of this case. The reasons was no contact with this child for over 6 months by Mr. Reid. The reasons were stated that Mr. Ernest testified, Mr. Reid told him, take her, I can't do anything with her. That was at the time when she was being checked into the hospital again for another period that she had to spend there because of the issues she had going on, and they couldn't get Mr. Reid on the phone. His brother had to get him on the phone and tell him, get over there to the hospital so you can get your daughter checked in because the Ernest can't do it and she needs assistance. That's another reason why they filed this, was to get things in order so that if they were going to have this child long-term, which they had already at that point, they were going to be able to take care of her and take care of her needs. And she had a lot of them at the time. You can deliberate or you can debate all day long whether or not the Reid should have filed a SAPSER or a termination or something else for that matter. But that's not the issue, Judge. The issue is, were there zero justifications for them filing the pleading at that time? And I think it's clear that there were plenty of justifications for them filing the pleading at that time. Dad hadn't had the child for over 6 months or had any contact or minimal contact, whichever testimony you believe. Dad hadn't supported the child for over 6 months. All of those things lead to the fact that this was a legitimate case that got filed. They can argue all they want about whether that offended Mr. Reid or upset him, but that's not the way the court needs to apply the law. The law needs to be applied in that, did they do it for the purpose of harassing? And there was not a legitimate purpose for the suit. They didn't do it. There was zero testimony about their intention for filing the suit other than the legitimate reasons that they set forth. That leads me to say there's absolutely no reason why this court should award Mr. Reid any attorney's fees in this case, because things happen and litigation happens. And the fact that he was offended by that or got upset by that is not the measuring stick. The measuring stick would say no justification for any attorney's fees. Now, on the Ernest side, they've got time that they've had to support this grandchild. And did they get any support for that? Well, they did at the very end. They got a little bit of Social Security. But if you add up what they got and then what they turned around and gave back to Mr. Reid that they hadn't spent on the child, they really didn't get much support for the 20 months they had this child. Is that really the issue? Is that really what they want? Absolutely not. But if Mr. Reid is going to push forward that they ought to be sanctioned for this and that they ought to pay his attorney's fees for this, then they ought to get what's due to them. If everybody ought to be accountable, so should Mr. Reid. And that's the basis of their case. We ask this court to award them a judgment for the fees that for the support that Mr. Reid failed to pay, and to deny his access, to deny his request for attorney's fees to be paid on behalf of the Ernest for them taking care of his granddaughter.
Thank you, Mr.
Sorry,
Gutierrez.
his daughter. Sorry, Judge.
Mr. Foster, your closing.
Thank you, Your Honor. Judge, this is about more than denying this father's access. These maternal grandparents filed a termination of his parental rights. And you can't go and say, you can file whatever you want. That's why they have frivolous pleadings and harassment to prevent this type of thing. If they thought that they made a mistake and they're blaming their old attorney and, oh, I don't know what he did, and I everybody else, let's sanction them. Let's make them pay for it, because they could have dismissed it immediately once they found out what they were actually filing. They knew what they were filing. They had a vengeance against Mr. Reid all these years, and you can believe one side or the other, but sometimes it's hard to do that, Judge. We've got the one in the middle. Jill, she testified. She clears up what's right and what's wrong. Her dad kept contact with her throughout this time. Not what the Ernestes said. Oh, he never contacted her at all. That is just not true. You heard it from the little girl's mouth. Her dad was always there for her at school events, going to the doctors. So he was always there. This case was filed over 3 years ago, Judge. They had every opportunity to let this go away. And opposing counsel is arguing that my client's all about money. The only reason he had to pay money was because they filed to terminate his parental rights for the rest of his life. And that is wrong. That needs to stop. That is why people cannot just file what they want. They need to be sanctioned, and they continue to do it without any remorse. And then on top of that, they decide once they think, oh, well, the judge might hit us with some fees. Let's file in March of 18th of this year. Let's file something to try and recoup some of our losses. Oh, we had, losses. And Jill was 20 years old when they filed this amended suit affecting parent-child relationship. There was never a suit affecting parent-child relationship in this case until March of this year. No mention of it throughout this case for 3 years of getting reimbursement or anything like that. It's just a ploy, Judge, to try and confuse the court and get to the real issue, which Jill has told the court, I didn't want this. I never said I wanted to be my dad's rights terminated or be adopted by my grandparents. They initiated this. They continued it for 3 years. And Judge, I think you need to show people that file these types of things, you can't do that. Otherwise, you get people filing these frivolous lawsuits.
Thank you, Mr. Foster. Boy, I can tell you that as a judge, I wish I could rewind 3 years and have the Ernestes go to another attorney's office rather than where they went, because I think there's been just so much damage done over the last 3 years with this litigation. And And this poor girl's in the middle of it and now having, it's just a shame. Because I do feel like the Ernestes went in to seek legal advice and to get counsel on what to do in the event that Jill went back into a hospital, or there were decisions that needed to be made and they just needed legal advice on how to get that done. And I think if the lawyer just picked up the phone and called Mr. Reid and said, hey, we want to just, during the time that this girl is staying with the grandparents, get your permission to make certain decisions, he probably would have agreed, and we wouldn't be where we are today, and there wouldn't be all this animosity between the parties. But unfortunately, they went to a lawyer that didn't do that, and ended up going a totally different direction that I know the three lawyers, or me and the two lawyers involved in this case, would have never done. But then it comes to the judge. Well, yeah, Mr. Reid's a victim of that, in that there was a bad pleading that was filed that ended up costing him attorney's fees. And do I punish someone else that is also innocent? That just chose a lawyer that chose a really bad course of direction that ended up hurting the case and hurting the relationships involved between the parties. And it's not an easy call from that standpoint, because I really feel like both sides in some regards are innocent. I know the parties are not going to agree with me there, but I can tell you as a judge, I don't think that the Ernest has had any ill intent going in and seeking legal advice. And I think Mr. Reid, same thing on him. I think if the Ernest had called him up and said, hey, we need some financial support for Jill when she's here with us, I think he would have agreed to pay that. Again, it's a matter of picking up a phone and talking to someone. And I think a lot of this probably would have been avoided. But unfortunately, we are where we are. And as a result of that, there's been a lot of damage to these relationships. And I can tell you, life's too short to harbor hatred and ill feeling toward other people. And it would be nice if this girl, Jill, could have both sides of her family. I mean, she's been through enough losing a mom at 3 years of age. It would be healthy for her to have contact with her mother's side of the family and feel love and support from her mother's side of the family, as well as her dad's side of the family. And those are things that she's an adult now. Those are things that hopefully will happen over time. But the court's ruling is as follows. Entry of this order is going to be for September the 10th at 9 a.m. First, the petitioner's request for Mr. Reid to pay financial support for Jill is denied in its entirety. Respondent's request for sanctions against the Ernest's petitioners for filing the lawsuit and for the attorney's fees associated with it is denied. All relief that was requested and or not requested before the court, or all other relief that was requested by the court, is denied. Mr. Kincaid, you're to draft the order, and that completes the ruling of this court. We're going off the record. Y'all are excused.